Roach. I represent the Texas Trial Lawyers Association and myself, and we are speaking respectfully against the bill. The bill, as it is enacted, will have a practical effect of greatly reducing, if not eliminating, the enforcement of compliance with these water regulations. As is indicated, what the bill says is that a renter has to exhaust their administrative remedies with the PUC before a lawsuit could be filed for a violation of this sub-metering law. The practical effect of that is I think the example that the Representative Lucio made is you have somebody in, for example, El Paso, and they're, a 20-year-old, 24-year-old kid, and they get overcharged by the water. Number one, it's unlikely they're going to know it. Number two, if they do know it, it's unlikely they're going to know that there's anything such as a Public Utility Commission to begin with. And so if they don't know that, assuming they do anything to rectify themselves, they're going to go see a lawyer. And if the lawyer looks at this and they see my sole ability to try to remedy this situation is to file an individual complaint with the Public Utility Commission, that's not going to be of any interest. And so compliance is not going to occur under this statute. I would point out that the way the statute is written, the statute says that if a tenant files a complaint, if you'll look on page 4, it says that the commission can require the owner to repay the complaining tenant. And so what that means is that under this statute, if a complaint is filed under this statute, the remedy of the PUC is specifically to the complaining tenant and not as a whole. As far as is this dealing with a litigation crisis, as was indicated, I think there's been a total of either 10 or 12 of these lawsuits that have been filed since the bill was first enacted. That certainly doesn't sound like a rash of litigation. And so, this argument really cuts in both directions, and that is if there's only been 10 of these cases, that indicates that the statute has been effective in ensuring that there's been compliance. But the other argument is, well, wait a minute, we're afraid that there's going to be a rash of these lawsuits in the future. Well, if that's the case, then what that's an indication of is that there is massive non-compliance with this statute. It's one of the two. And so if there's massive non-compliance with this statute, that has an effect on water conservation, because the purpose of this statute is twofold. There's a tenant protection purpose of the statute. There's a water conservation purpose of the statute. And as far as this primarily being some kind of technical, non-monetary issue, I would point out the last case that I saw that was filed, the allegation in the case was that the tenants were being charged almost twice as much as the actual cost of their water. I'd also point out a number of these cases have been brought because, in addition to charging more for the actual amount of water, in some cases they're being charged a administrative fee add-on for sub-metering the water, and the statute specifically says you can't do that. And so for those reasons, we are opposed to the bill. We believe that it is, from a consumer protection standpoint, it is anti-consumer protection as written. We think from a conservation standpoint, it's anti-water conservation. And we think it's also anti-growth and anti-economic development, because water resources are important considerations that businesses make when deciding where to locate businesses and housing. And if water is not available or water is limited, that affects whether businesses come to certain areas of the state. And with that, I'm open to any questions.
Yeah, with all those antis, Nelson, I'm pretty certain you're against this bill.
Yes.
Yeah. Okay, Chairman King.
Thank you, Mr. Chairman. Mr. Roach, there was some mention made a minute ago that when was this statute put in place?
I think it's been in place for a long time. It's I believe more than 10 years.
Well, somebody said a minute ago that there have been cases where suits were filed because people didn't sign up correctly or something like that, and it wasn't actually an overbilling.
I'm not aware of that. I'm aware that there has been one case, I think, that was filed because the apartment complex didn't have 3.5-gallon toilets, and that's required under the statute. But under those circumstances, it's not a circumstance where the person gets back all of what they paid for water. It's a circumstance where they get what they're entitled to recover is the amount of overcharge or a 1-month penalty for not complying with the code. But the point of the matter is that I think what the evidence indicates, in light of how few of these actions that have been brought, is that there has been widespread compliance with this statute. And what I would suggest to you is if you remove the enforcement mechanism from the statute, then you're taking away the incentive that has brought about compliance with this statute.
Well, I mean, I certainly agree with that, but I just was kind of curious about how it was just an issue that I'd never seen before. And typically, so if somebody sues and they're being overcharged on their water bill, and when you're talking about, for example, was double, so instead of a $25 water bill, they got a $50 water that they're being charged for, then they're successful with their suit. So then what is, at the end of the day, what is the financial liability that the apartment complex has?
Well, if it's brought as a class action, the apartment complex will have the responsibility to pay back what they overcharged.
Okay.
And then unless it's a innocent violation, they'll have to pay trouble damages, a 1-month penalty, and attorney fees. I mean, the penalty is strong.
That's the Deceptive Trade Practices.
It's not in the Deceptive Trade Practice Act, but it is very similar to the DTPA. In fact, you know, the remedy situation, the attorney fees situation, all of that is consistent with what you find in the DTPA, and that is it's a series of consumer protection laws that have those provisions to incentivize people to bring these small claims. And the reason why you want to incentivize people to bring these small claims is to ensure compliance.
So, have there been instances where people claim that somehow that, yes, we were overcharging, but it wasn't intentional, and they avoided the deceptive trade, I'm calling it deceptive trade practices, but the triple damages? There's
a defense in the statute, an innocent defense in the statute, and so they can plead that as defense. It's a defense to the penalty.
Yeah. Has anybody been successful doing that you know?
I honestly don't know. I'm from Dangerfield, Texas, and we're population 3,558, so we don't have too many apartment complex cases in Dangerfield.
Thank you, Mr. Roach.
Thank you.
Anybody else have any questions for Mr. Roach? Thank you, Nelson.
Appreciate it.